with us this afternoon, and I want to start by thanking my distinguished vice-ranking member of the Oversight Committee, Congresswoman Alexandria Ocasio-Cortez from New York, for her superb, outstanding work on this panel, and I do hope that it is the beginning of her journey perhaps to law school, she could go to law school part-time. This is what Senator Robert Byrd did. I happen to know that because he went to law school where I taught, American University, Washington College of Law, and of course he went on to become our preeminent constitutional champion in the Senate, a position now held by our first witness from the U.S. Senate, Senator Sheldon Whitehouse, who represents Rhode Island, of course. He's the chair of the the Senate Budget Committee, and he has been working expertly to try to restore both the integrity and the reputation of the Supreme Court and to specifically combat the infiltration of dark money into the federal judiciary for many years. We are going to make our opening statements and then turn it over to you, Senator Whitehouse, unless you need to get back to the Senate for a vote or something right now.
At your pleasure.
Okay. Well, welcome, and thank you for joining us. I will recognize myself now for my opening statement, and then I'm going to turn it over to the vice-ranking member. The crisis on the Supreme Court today has multiple dimensions to it. It's not just the ethical crisis, which the whole country is talking about. It's the doctrinal and the political crises as well. These are interlocked and they're mutually reinforcing, and it all adds up to one profound crisis of constitutional legitimacy in the country. The seminal moment for understanding our current situation took place back in 2000 with the 5-4 decision by the Supreme Court in Bush versus Gore to intervene in Florida's electoral process to stop the counting of ballots, thereby handing George W. Bush, who was the national popular vote loser, the presidency on the most fallacious and dubious of grounds. The court never explained why blocking the counting of more than 100,000 votes vindicated equal protection, a constitutional principle that had completely abandoned, of course, came to the rights of racial minorities and women, nor did the right-wing justices show much faith in the logic or integrity of their own ruling when they said, quote, "Our consideration is limited to the present circumstances, for the problem of equal protection in election processes generally presents many complexities. That inscrutable reasoning offered in order to deny any precedential effect for Bush versus Gore is, of course, the precise opposite of the rule of law, which depends on clarity, logic, reason, and precedent. But it did lead to the exquisite logical paradox that if you follow Bush versus Gore, you cannot treat the case as precedent, but since you cannot treat it as precedent, then the passage saying it cannot be precedent itself should not be followed. In practice, hundreds of federal and state decisions have cited various aspects of this outrageous decision. For our purposes of understanding why the Supreme Court's public reputation is in the gutter today, the key point is that George W. Bush's 5-4 victory in the Supreme Court allowed him not only to name John Roberts Chief Justice, but to replace the fairly moderate Justice Sandra Day O'Connor with Samuel Alito, a hard-driving, anti-union, pro-NRA Federalist Society lawyer and judge. Everything would have been different completely today if Al Gore had not been denied the presidency by the Supreme Court, and we had in the place of Justices Alito and Thomas today, speaking hypothetically, Larry Tribe and Sheldon. But that new right-wing 5-4 majority, which included Clarence Thomas, who astonishingly replaced Thurgood Marshall and was the appointee of George Herbert Walker Bush, proceeded to dramatically erode the voting rights of the people and set the stage for a resurgence of political white supremacy. There are many relevant cases in this genre, but consider this key one. In 2013, in Shelby County versus Holder, the 5 right-wing justices cut the heart out of the Voting Rights Act of 1965 by essentially nullifying the central Section 5 federal pre-clearance mechanism by finding the Section 4 coverage formula was now obsolete and dysfunctional because there was no more racism in the political system. In dissent, Justice Ruth Bader Ginsburg likened it to someone deciding to throw away their umbrella in a rainstorm because they weren't getting wet. This decision, within just weeks and months, led to a dramatic rise in voter suppression and disenfranchisement tactics and schemes throughout the South and in other areas, with 15 states canceling online voter registration, early voting, mail-in balloting, same-day voter registration, and other recent reforms, and imposing serious new blockades and obstacles to participation, including photo ID laws, regular mass purges in the voting rolls of voters who miss a single election, and the closure of 868 polling places, predominantly in African-American communities, all in the 3 years immediately after the decision gutting the Voting Rights Act and leading up to the 2016 presidential election. Now, although Hillary Clinton beat Trump by more than 2.5 million votes nationally in the popular vote, he still eked out an electoral college victory in 2016. So that popular vote loser and electoral college winner then came to name 3 right-wing Supreme Court justices of his own: Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, all 3 of them under radically questionable and dubious circumstances. Neil Gorsuch got the seat that President Obama had nominated Judge Merrick Garland to. Garland was, of course, the chief judge of the D.C. Circuit Court of Appeals and was arguably, indisputably, in my mind, one of the most qualified people ever to be nominated to the Supreme Court. This was the vacancy created by the death of Justice Antonin Scalia in February of 2016. President Obama nominated Merrick to fill the vacancy on March 16, 2016, but Senator Mitch McConnell, in his wisdom, said there would be no hearings or votes because 9 months before the new presidential term was too close, and the people should decide, with only 9 months to go. Of course, the people had decided when President Obama was elected to one of those genuine, bona fide constitutional 4-year terms as President of the United States. But McConnell successfully blocked any hearings into his nomination of Merrick Garland and any consideration of the nomination. The seat remained vacant when President Obama left office. Then, when Trump got in, he immediately nominated Neil Gorsuch, another right-wing conservative. And to demonstrate how arrogant and devil-may-care the right wing has gotten about running roughshod over all principles and norms that might interfere with their absolute determination to control the judiciary, including the norms and principles they have made up themselves in the past, consider that when Ruth Bader Ginsburg died on September 18th, 2020, less than 2 months before the general election, when early voting had already started in several states, McConnell literally laughed at the idea that he would be bound by the precedent he had created just 4 years before in the Senate with the Merrick Garland nomination and the Scalia vacancy. The Senate proceeded to ram through Amy Coney Barrett's nomination like a thief in the night. And I don't have time even to get into Brett Kavanaugh's nomination, but everyone here presumably understands what happened there, and a new documentary is coming out on the brutal miscarriage of justice that took place. Now Donald Trump is bragging all over America that, quote, after 50 years of failure with nobody even coming close, I was able to kill Roe versus Wade, much to the shock of everyone. He and Mitch McConnell packed and stacked and gerrymandered the court. And now this right-wing corporate court, carefully designed to destroy Roe versus Wade and to fuse right-wing religion with untrammeled corporate power, has been demolishing women's abortion and contraceptive rights, civil rights law, voting rights law, civil liberties, environmental law, workers' rights, and consumer rights, enshrining government power over people whenever they conflict, and corporate power over government whenever they conflict. The court has been behaving like a rabid partisan actor. A few weeks in Alexander versus South Carolina NAACP, another
The right-wing majority upheld a congressional redistricting plan that the plaintiffs described as a blatant racial gerrymander designed to thwart and dilute the voting rights of African-American voters in South Carolina. But the right-wing majority held that the African-American plaintiffs had failed to show that the majority white legislature was motivated by race when it relocated thousands of black voters out of the 1st congressional district, dramatically changing the political balance of power in that district. Justice Alito held for the majority instead that the legislature was merely seeking to make the seat safer for Republicans, which is a legitimate goal, Justice Alito said, and does not violate equal protection. Under this court, it violates equal protection when Florida just tries to count ballots in Florida, but it does not violate equal protection when African-American voters are drawn out of a congressional district to create a safe white majority Republican district. Constitutional doctrine has been reduced in this court to a series of blatantly unjust and thoroughly ideological decisions like these, upholding white political supremacy, racial inequality, corporate power, and right-wing control over our democratic institutions. All of the preening lectures about textualism and originalism today are nothing but a fraud on the public, and I want to get into that today. And I want to talk about Citizens United, if we get the chance, with Senator Whitehouse, and I want to talk about the Second Amendment jurisprudence too. But in sum, the right-wing justices, 5 of them named to the court by Bush and Trump, the 2 presidents elected in this century to the presidency after losing the popular vote, now act entirely like the judicial arm of the Republican Party, which represents a small minority of the American people. It is no coincidence that Justice and Mrs. Alito today brandish the flag symbols of insurrection, of disunion, and of Christian white nationalism. It's no coincidence that Justice Thomas takes millions of dollars from his right-wing corporate sugar daddies. After all, if you can decide presidential elections with 5-4 votes in Bush versus Gore, if you can pack, stack, and gerrymander not just Congress, but the Supreme Court itself by denying the other party even a hearing, why can't you have some friend of the court, some amicus curiae, fly you to Bali for vacation, or pay for your family member's private school tuition, or buy you a recreational vehicle, or send you on a lavish, all-expense-paid vacation? Why the hell not? The highest court in the land today has the lowest ethical standards, and yet they are the only jurists in the federal system who are traditionally given the honorific justice rather than judge. And yet, with their lopsided ideological jurisprudence assaulting the rights of the people, and with their obscene ethical transgressions, they've completely forfeited their right to be called justice. And unless I forget to do it, from now on, they're just Judge Alito and Judge Thomas to me, at best. I look forward to hearing from our excellent panelists today about how we got into this predicament and how we can get out. And I now happily turn, I will recognize Vice Ranking Member Ms. Ocasio-Cortez for any remarks she sees fit to make.
Thank you so much, Ranking Member Raskin. It's an honor to be here today for us to convene and discuss arguably one of the most critical issues before American democracy today. And with respect to law school, maybe if you're my professor, Mr. Ranking Member, I'd be happy to explore the possibility. But back to the matter at hand. The Supreme Court is currently facing a grave crisis of legitimacy, and it is a crisis of its own making. About 50 years ago, a group of powerful, wealthy, conservative operatives looked around and realized that they were losing. In 1964, the Civil Rights Act had passed, prohibiting discrimination in the United States on the basis of race, color, religion, sex, or national origin. In 1970, at a time when rivers were literally catching fire from pollution, the federal government created the Environmental Protection Agency, finally taking a measure of responsibility for the health and safety of working people and our climate, and confronting polluters and corporations in the process. And most alarmingly to these men, 3 years later, in 1973, the Supreme Court decided Roe v. Wade, giving women reproductive freedom, enshrining a right to privacy, and marking a major advancement for bodily rights and autonomy. The nation was changing, and it was changing to more fully realize our country's promise, a democracy for the people, by the people, with liberty and justice for all. But this new world, a multiracial democracy with civil and economic rights enshrined in American society, threatened the power of the very people who relied on this discrimination and subjugation of others. These wealthy, conservative men knew that they could not win the argument on merits. So they hatched a plan to manufacture a structural assault on the American judicial system. In 1973, the same year as Roe v. Wade, the Heritage Foundation was born, and with it, a decades-long scheme to push back on these ideals and cement a hierarchy that these men, the elite 1%, could remain on top, to roll back our rights. Today, we're here to talk about how they did it and how we may win the struggle back for American democracy. They did not have popular support. They did not have elected office, but what they did have was money, and a lot of it. One of these men is Leonard Leo, who joined the fight in 1990. Leonard Leo became one of the movement to corrupt the court's most prolific fundraisers. Leo organized right-wing billionaires to shore up an infrastructure to influence the judicial nomination process and seats on the Supreme Court, wholesale. He funded group after group to spread his and his billionaire friends' reactionary ideology onto the American public. These right-wing billionaires include characters such as oil and gas magnate Charles Koch, hedge fund manager Paul Singer, and Nazi paraphernalia collector Harlan Crow, the son of the quote-unquote biggest private landlord in the United States. These billionaires have never been elected to public office. They are not our leaders and are unknown by the vast majority of Americans. And yet, they worked with shadowy, extremist, right-wing figures led by Leonard Leo to create a corruption ring of influence that reached the highest levels of our country and our courts. These billionaires hatched a plan to use massive floods of anonymous donations, political obfuscation, and outright gifts and ethics violations to reshape the courts. And so far, to this day, they have experienced success. Let's be clear. Justices Clarence Thomas and Samuel Alito are deeply subject to and are exacting the agenda of these billionaires, and they act like it. Just look at Clarence Thomas, whose corruption is almost comical. Secret trips to retreats, international vacations on super yachts, and private jet jaunts to New Haven for an afternoon. Here in Congress, we are forbidden from receiving gifts that exceed $50. But Justice Thomas has received more than $4 million in gifts, largely undisclosed, since joining the court. And worse, it appears to be working. He is currently primed to overturn his own 2005 doctrine so he can side with Charles Koch's network and their oil and gas interests, the same Charles Koch who he secretly vacationed with at the retreat. Or take Justice Alito, whose quote-unquote friendship with billionaire Paul Singer, along with more undisclosed gifts and private jet trips, was followed by a shift in the court's decision to take up Singer's own case. Coincidentally, after Justice Alito took an unreported fishing trip to Alaska with Singer, the Supreme Court reversed their position and took up his case, ultimately leading Singer to a victory netting $2.4 billion. This was not a bad return on Singer's $80 million in political donations, a fishing trip, and a couple bottles of $1,000 wine. And of course, in 2022, these billionaires and their handpicked justices won their keystone victory against the American people and their progress as a society. They overturned Roe v. Wade. So why was it abortion? Why was the threat of women having freedom powerful enough to bring down our whole system of judicial ethics and cripple one of the three co-equal branches of government? That is because these rich and powerful men are in an existential fight for a status quo that enshrines their power and places them above the American public in the rules. The confluence of money and conservatism is no coincidence, and we are here today to connect the dots. The group behind the Dobbs Challenge was, predictably, funded by who else but Leonard Leo, and found a friendly court in front of right-wing extremists. And we've also seen, as well as the conservative justices Clarence Thomas and Samuel Alito. After all, these justices clearly continue to agree to this bargain by continuing to accept and engage in this ring of influence and financial persuasion. This brings us to the crux of the matter and why we're holding this hearing today. The Supreme Court, as it stands today, is delegitimizing itself through its conduct. Americans are losing fundamental rights in the process: reproductive health care, civil liberties, voting rights, the right to organize, clean air and water, because the court has been captured and corrupted by money and extremism. There is no one decision that determines the court's legitimacy. Instead, it's the entire strategy that led us to this point. A group of anti-democratic billionaires with their own ideological and economic agenda has been working one of the three co-equal branches of government. And let's be clear, the Supreme Court is a co-equal branch of government. They do not reign supreme over Congress or the White House. This is a very core crisis of legitimacy, and it is a core crisis within the court, of our multiracial democracy, and of who we are as a country. The responsibility for the erosion of the court not only lies in the court, it lies in Congress. And it's not just what they do, but if we let it happen. And we cannot allow this to happen. We must treat this moment like the emergency it is and use every tool in our democracy's arsenal to fight back. The future of our democracy depends on it. And with that, I yield back to the ranking member.
And thank you very much, Ms. Ocasio-Cortez. We're going to open now with our first panel, which is Senator Sheldon Whitehouse from Rhode Island. He has been blowing the whistle on the ethical and constitutional deterioration of the Supreme Court for several years now, and has focused a lot of his energy on mapping out the dark money networks behind the corruption of the Supreme Court. He has a book, which I recommend highly to you all, called The Scheme: How the Right Wing Used Dark Money to Capture the Supreme Court. He's introduced a lot of legislation to curb anonymous dark money groups, including the End Tax Breaks for Dark Money Act, which would close tax code loopholes, allowing billionaires to avoid capital gains taxes by donating money to dark money groups, and the Disclosure Act, which would require groups that spend money supporting or opposing judicial nominees to disclose who their donors are. I want to welcome you, Senator Whitehouse. It's been a pleasure to work with you on this, and also on the whole question of the oil and gas industry's complicity with the cover-up of the science relating to climate change. And you are recognized for whatever remarks you would like to share with the committee.
Thank you so much, Congressman Raskin. It's wonderful to be with you and with Vice Ranking Member Ocasio-Cortez, and a particular shout out also to Congressman Hank Johnson, who has the coordinate position that I have, which is the lead Democrat on the Court Subcommittee of the Judiciary Committee, and who has been outstanding to work with across several years and many issues. The context for this conversation is rooted in the doctrines of regulatory capture and agency capture. These are doctrines about which there is much literature and also much sad experience. Some decades ago, the evil genius of the scheme was to take the tactics of regulatory capture, agency capture, and apply them not to administrative agencies, but to our courts, in particular to our Supreme Court. And in the service of that, we have seen the billionaire-funded judicial selection process nominally run through the Federalist Society, but if you look at the records of the Federalist Society, you can't actually find recommendations or support for the so-called Trump list. That was cooked up in a back room somewhere by Leonard Leo and his funding billionaires. The selection process puts them on the court. Then the Billionaire Gifts Program kicks in to make sure that the amenable justices are provided lifestyles of the rich and famous. At the same time, the billionaires fund dark money factories in friendly think tanks and universities, and the doctrines that are cooked up there, like the Major Questions Doctrine recently applied, are then brought to the court through flotillas of billionaire-funded amici curiae, usually appearing in sort of 10 to 15 number flotillas, but sometimes as many as 50 in cases where the billionaires really want to signal hard to their hand-picked justices that this is a big one and they need to comply. And of course, the whole thing is juiced with dark money, funding all of these various enterprises and also funding Senate Republicans who then obediently provide confirmation for the selected justices. What are we doing about that over in the Senate? I'll give you a very quick run through. First of all, we've been trying to put a heavy spotlight on the mischief to create pressure within the court and within the judiciary for it to manage its own reforms. We've seen some success from that. The Supreme Court has gone from don't bother us, go away, to okay, here's a letter signed by all 9 of us to discuss the position that we take with regard to our ethics, to okay, that didn't work. Here's an ethics code that we're adopting for ourselves with a few modifications. And most importantly, no investigation, no enforcement. So there are very big gaps in where we are. The 9 justices of the United States Supreme Court are the only officials in the entirety of the United States government as to whom, when an ethics challenge is raised, there is no fact-finding done. Even the president had to be interviewed about the status of the documents in his garage, not these 9. They're the only ones. The pressure campaign has worked to the degree that they are now at least nominally under an ethics code, but we need to keep the pressure on until they join the rest of the government in having a real ethics code with real fact-finding and some prospect for comparing the facts that are found to the rules. So that's Avenue 1. Avenue 2 is legislation. The ethics bill that we have is through the Senate Judiciary Committee, waiting a vote on the Senate floor, and I hope and expect that we will have that vote in this Congress. And a term limits bill, and I want to again congratulate Congressman Johnson for his term limits bill. We don't have perfect alignment between our bills, but we're pointing in the same direction, and we're not going to pass them unless the voters put Democrats in charge, and at that point I think we're close enough that we can easily reconcile our bills and provide real term limits that the public really likes for Supreme Court justices. The third avenue is investigation. I sit on the Judiciary Committee and on the Finance Committee. Both committees have been engaged in investigative activities. The Judiciary Committee gave Chairman Durbin subpoena authority, and investigations are being pursued with the power of that subpoena authority. I would note that the power of that subpoena authority has been somewhat limited by the loud declarations by Republican senators that the subjects of those subpoenas should not comply with them, and that they would never allow them to be enforced if the subjects refused to respond. So I hope and pray that the time will come when the House is issuing subpoenas in this space that are not subject to the Senate filibuster. On the finance side, the Finance Committee developed the information that the $250,000 loan for Justice Thomas's motor coach was never repaid. Some interest was paid, and then all payments stopped. And we continue to look into the final facts of what actually took place, but no principal on a $250,000 so-called loan appears ever to have been repaid. Harlan Crow appears to be playing tax games with the yacht that he took Justice Thomas around Indonesia on, in that in some places he called it a pleasure yacht, in some places he called it a charter yacht. We interviewed his crew who said they could never remember a charter, and yet he took millions of dollars in tax deductions as if it were a charter yacht. It looks a lot like a billionaire deducting the expense of operating his own toys, which is not what the tax code permits, so that remains under further investigation. The last piece, the Fourth Avenue, has been working with the Judicial Conference, with the other distinguished senior judges, chief judges from circuit and district courts, who are the oversight body for the judicial branch within the judicial branch. It is a body established by Congress to enforce laws passed by Congress, and they have given 2 victories for transparency and integrity that I think are very important. The first was to explode what I call the Scalia trick. The Scalia trick was to arrange for the owner of a private resort to invite Justice Scalia on a free vacation, and then to fail to disclose the vacation on the theory that the free vacation gifted by the owner of the resort, whom he may never have met, was a personal invitation. And as a personal invitation, it therefore amounted to personal hospitality and needn't be disclosed. We believe he took over 60 of these free arranged vacations. The Judicial Conference took a look at that and blew it to smithereens, because they know perfectly well that would never fly in any circuit court or in any district court in the country. The second victory for transparency and integrity there, if you go back to my description of how the court capture scheme worked, it involved communicating to the justices what it was that the billionaire interest wants through these flotillas of front group amici, who would then not disclose who was really behind them. In one occasion, a brief was filed by an entity which is not even a real corporate entity. It was the fictitious name under Virginia corporate law for a separate corporate entity under which fictitious name that other corporate entity had registered to do business. They didn't even disclose to the court and to the other parties who the real corporate entity was for whom this was the fictitious name. And just last week, the Judicial Conference announced its new rule demanding significantly more, its new proposed rule, I should say, demanding significantly better disclosure. So the bad news is that we have a rogue court that has been captured by special interests and that is over and over again in appalling pattern continuing to follow the direction of the billionaires and the front group through which they operate. The good news is that the public is fed up. Congress is fed up, mostly. And the Judicial Conference is beginning to tighten up the rules on the Supreme Court justices. I'll close by pointing out that the case is often made that Congress has nothing to say about regulating the ethical conduct of the Supreme Court justices. The Supreme Court justices' own behavior belies that notion. When the first round of Harlan Crow to Clarence Thomas gifts of free yacht and jet travel came out back in 2010, 11, and 12, those questions were referred where? To the Judicial Conference, a body established by Congress. For what? For review under the disclosure laws passed by Congress. And through all of that process, we had a judge who was involved in that point out weaknesses in the process at the time. But what didn't happen in that process was for Justice Thomas or any of the other Supreme Court justices to say, wait a minute, you have no authority over me. I am not subject to the disclosure rules. You cannot investigate me. There's even a remedy if it looks like the failure to disclose was willful, for a referral to the Attorney General for a proper full investigation. And that question, whether the Harlan Crow to Justice Thomas second round of yacht and jet travel gifts should be referred, is before the Judicial Conference right now.
Senator Whitehouse, thank you very much. We're now going to enter into our Q&A portion. Each member of the Oversight Committee will be given 5 minutes. We're also delighted to be joined by Hank Johnson, our colleague from Georgia from the Judiciary Committee, who chairs the subcommittee on the courts there, and we're going to give you your 5 minutes as well. And so I'm going to kick it off with this. What's the relationship, Senator Whitehouse, between the private corruption of the justices and the public corruption of justice? Because you could imagine if we had a squeaky clean Justice Alito and a squeaky clean Justice Thomas and so on, they could still be visiting all of this damage on all of our legal doctrines. And yet somehow to me it seems like it's not just a coincidence and a happenstance that we get this steamroller against all of the legislative output of the civil rights movement and the women's movement and the labor movement and the environmental movement at the same time that we get this astounding private corruption of the justices. So just wonder about your reflections on that.
Years ago when I began this effort, I took a look at the 5-4 decisions in which the conservative majority was unified but couldn't attract one of the other votes. And there were 60-some decisions in which that was the count, and an issue obviously relevant to a Republican special interest was involved. They won every single time. It is a pattern that any good lawyer would take into court to prove bias, and the other side would probably settle. So the pattern is very, very telling. And if you think back to where agency capture, which became court capture, came from, it began with folks like railroad barons putting their folks onto the Railroad Commission so that the railroad rates that the Railroad Commission set would be just exactly what the railroad owners wanted. So the model fits, the pattern fits, and what else fits is that where there's a discrepancy between where conservative doctrine would take you and where the interests of the billionaires behind the scheme would take you, they chuck the conservative doctrine, kick it to the curb, and go with what they know is wanted. There's probably no better example of that than Citizens United, which is about the least originalist, historically based decision you could possibly imagine.
It has nothing to do with the original meaning of the First Amendment.
If you want to find originalism, you have to look to the dissent.
Yeah. All right, but now the right wing does be very anxious about what's going on in America today, because the American people reject all of this. Yeah. People understand, the idea of an umpire calling balls and strikes, as Justice Roberts put it in his confirmation hearings before. Don't put up flags of one of the teams, and umpires don't have their wives lobbying to overturn the results of the last game, and they know that umpires are not given million-dollar trips by the owners of the specific teams and so on. So they've got a real problem, but what they're saying now is that we are violating the separation of powers by compromising judicial independence, by not allowing them to be the judge in their own case and decide about their own ethical impartiality and probity to make specific Supreme Court decisions. What about that? You've thought a lot about that. Is this an assault on the separation of powers that the American people and their representatives in Congress are trying to get a hold of this ethical crisis?
It is no more an assault on the separation of powers than Congress providing ethics and disciplinary rules for executive branch officials would be. which we do all the time.
And we've done for decades,
And
right?
we've done for decades. And in fact, we have seen senior executive branch officials get prosecuted as criminals for instance, 18 U.S.C. 1001 false statement violations for failures to disclose gifts and emoluments that are pretty minor when you consider the scale of the millionaire gift program for the amenable justices.
And if we're not supposed to have these overlapping checks and balances, why do we have the power to impeach Supreme Court justices and convict them, right? Why do we have the power to control their budget? Indeed, why do we have the power to control the appellate calendar and their appellate jurisdiction? So that argument seems overwrought to me. I want to ask you finally about judicial recusal. There's been a clamor in the country to try to get Justices Alito and Thomas to recuse from January 6th related cases before the Supreme Court right now. One relates to President Trump's extraordinary invocation of the idea of absolute former presidential immunity from prosecution for crimes that may have been committed while in office, and the other relates to the interpretation of a particular statute. But I've been advancing the idea that the Department of Justice could seek a writ of mandamus to try to get the Supreme Court to compel the federal officials who are these Supreme Court justices to recuse themselves in accordance with very clear Supreme Court case law and doctrine. Chief Justice Roberts seems to have come out very quickly and said, no, that can't happen. The court is not going to get involved. What is it we can do to try to vindicate the very intuitive notion that no judge, no person should be a judge in his or her own case?
The most obvious thing that we could do would be to make sure that there is proper and honest fact-finding about what actually took place. The baseline for any process of law is proper, neutral fact-finding. Everywhere you go, government officials are subject to proper fact-finding when claims are brought against them, except for 9 individuals who are the Supreme Court justices. And we've seen this play out in the recusal context because Justice Thomas has refused ever to disclose what the facts are about what he knew about his wife's insurrection activities and when he knew it, which is the absolutely salient set of facts to determine whether he should have recused himself in January 6th related cases. Similarly, we have seen Justice Alito discussing his multiple MAGA battle flags make factual assertions that are demonstrably not true as regards the timing of the incident and so forth. So just getting the facts right will make a really important difference. And the notion that nobody can go, a Supreme Court employee, that no Supreme Court staff attorney could go in and say, sir, we've had this allegation about you, we need to settle it. I need an hour of your time to answer some questions. This is a formal statement for purposes of, the way the federal law responds to truth-telling. And so could you tell me a little bit about this, that, and the other, and at the end when we're done, would you mind signing the statement? That does not impede separation of powers at all.
No.
And they could set that up readily, and then at least you'd have a true statement of what the facts are to compare to how everybody else in the judiciary behaves.
Well, thank you, Senator Whitehouse, for always flying the flag right side up and reading the Constitution in forward direction. And I'm going to yield now to Ms. Ocasio-Cortez for her 5 minutes.
Thank you so much, Ranking Member, and thank you, Senator Whitehouse, for joining us today. You mentioned in your opening remarks a very crucial mechanism, the Judicial Conference.
Yes.
The Judicial Conference is a body created by Congress in 1922, well over 100 years ago, to administer and enforce rules on the judicial branch. The Judicial Conference was created to address unethical situations, almost exactly the kind seen in Clarence Thomas's case and Samuel Alito's case. And it is meant to really sort through, as you mentioned, and make determinations about when these situations arise. But there's a problem here that we are running up against when it comes to the Supreme Court. And I believe it is that the court has to allow investigations and allow them and offer this information and comply with investigations with by the Judicial Conference. And I think that's where we get to the crux of one of the crises that is unfolding from the court, which is the role of Chief Justice Roberts in how he presides over the court, the decisions that he is making with this misconduct going on. Can you tell us about how the Supreme Court and specifically the Chief Justice have addressed these scandals and responded to your oversight attempts? And has the court indicated a path forward in terms of how they seem to intend to engage in oversight investigations?
The Chief Justice is the chair of the Judicial Conference. He's the only member of the court who participates in it. And in that role, he has allowed the Judicial Conference to kill off the Scalia trick. And he has allowed the Judicial Conference to investigate Justice Thomas's dealings with Harlan Crow, an ongoing investigation right now. And he has allowed it to begin the process of cleaning up the secret fake front amici curiae flotillas. So obviously he could do more. I suspect he could do a good deal more as Chief Justice. It strikes me that if this is a court that can take away women's rights to their bodily autonomy, people in this country, rough numbers, they ought to, by a simple majority, be able to apply to themselves the same kind of ethics procedures that every other federal judge has to follow.
And itself, and as you mentioned in your opening remarks, that you may have some Republican colleagues that are loudly claiming that the Supreme Court should not comply should a subpoena be issued by Congress into the misconduct of the court. I think it's very important for us to refuses or would refuse to comply with a potential subpoena issued by Congress. What would be the implications of such a radical, and what could that unleash on our democracy?
Well, we may have to find out. What we know is that the Chief Justice has declined both to come to a Senate Judiciary hearing and even to meet with senators on the Judiciary Committee to discuss the problems over at the court. In the context of the request for him to discuss the most recent, what I call the MAGA battle flags, Justice Alito with his version of events. So they have communicado the way Thomas has been. I would note one interesting thing about Justice Thomas's engagement with us. He's generally completely mute when it comes to questions about ethics and facts. But when the Judicial Conference exploded the Scalia trick. That's the one time when he had something to say. And what he said was, I will comply with this new rule. And everybody in Washington looked at I will comply and got completely transfixed by that. But as lawyers in the room would know, the operative language in that sentence is this new rule. The explosion of the Scalia trick was described by the Judicial Conference as a clarification, which means retroactive, which means that he and Justice Alito would have to go back and clean up a lot of misfilings. So when the only time he's spoken to these issues, said this new rule, he was closing a door for himself, in contrast to the language actually used in the letter to me by the Judicial Conference. And the Judicial Conference is now reviewing whether, when they said clarification, they meant clarification. And if they make that decision, then we'll learn a lot more about the Billionaire Gifts Program.
And very briefly, so much of the structure of our democracy and our governance relies on checks and balances, a system of checks and balances between these three co-equal branches of government. And much of that authority of the court, when the court overrules the executive branch or Congress, the expectation is that those branches would comply with the ruling of the court. And this comes to a core basis of enforcement. And I suppose a question that I would pose is, if the court does not comply with Congress, what mechanism and authority do they wish to assert or use to have Congress comply with them?
There is a abiding tension that Congressman Raskin probably knows better than anyone in separation of powers doctrine between the separation of the branches and the co-equality of the branches as checks and balances on one another. And that is very much the center of the conversation we are having with the court right now, and with some of our Republican colleagues who see only the separation of the powers, but don't see the co-equality and the checks and balances.
Thank you very much. I'm going to move quickly now because Senator Whitehouse is going to have to leave, I think, at 5:15. And so, Ms. Norton, I'll come to you, and then I'm coming to Ms. Stansbury. Hopefully we'll get in the others, but we'll pick up with you guys for the next panel. Ms. Norton, you're recognized for your 5 minutes.
Senator Whitehouse, I'd like to ask you about dark money. I'd like you to discuss what dark money is, who controls it, and what is the purpose of this so-called dark money?
Dark money is the rot in our democracy right now. It is controlled by definition by billionaires and wealthy special interests who have the ability to spend millions and millions of dollars in politics, the motive to spend millions and millions of dollars in politics, and the desire to obscure from the public who they are when they spend it, so they can't be held accountable. We have the ability to cure it. If you read the Citizens United decision closely, it stands for the proposition that dark money is corrupting, which is why it went through the elaborate pretense about how all this money would be transparent. So we can fix it. The Disclose Act would fix it. That was part of H.R. 1 in the last Congress, and I hope if the voters vote for reform in the coming election that we are actually able to pass that bill and clear the dark money out of our politics. As a climate advocate, I watched bipartisanship on climate issues in the Senate drop dead in January of 2010 from a very robust bipartisan conversation in which the flag carrier, John McCain, for the Republican Party in that presidential race, had a perfectly good climate platform, to like a heart attack It just flatlined after January of 2010, the date of the Citizens United decision, and no Republican in the Senate has joined a serious climate bill since. Effect, and I think industry spends a lot of the dark money, so they're very happy at the situation they've created in postponing climate regulation for over a decade.
What is this dark money spent on, and how is dark money utilized to help sway the outcome of Supreme Court decisions?
The most immediate and direct dark money, under the purest definition of the term, is money that is spent in politics by hidden special interests. So a big special interest sends $20 million to a front group. The front group then puts it into a super PAC. The super PAC then spends it in support of or against a candidate and only reports the front group. Obviously, the big special interest will communicate to the candidate they're supporting, we just spent $20 million for you. It's only the public that's left in the dark. But it also turns up in the Supreme Court through these front groups that file amicus curiae briefs and little flotillas who, by virtue of not disclosing who's behind them to the court or to the other parties, can obscure the fact that they're really piano keys on the same piano. It's a concerted effort. It's a set of sort of dark money chords that are presenting an argument in harmony to the justices. And then if there's one consistency with the right-wing justices, it's their alignment with the direction provided by those dark money front groups in the amicus flotillas.
Well, I'd like to ask you how dark money is utilized to help sway the outcome of Supreme Court decisions, for example, in terms of the nomination and confirmation of judges during Republican administrations.
I would say that I've used the phrase that this is dark money built. And it built it through contributions to the Republican Party. But that then go out and lobby for issues, file amicus briefs for issues, in many cases litigate cases as the real party in interest. They'll go and find a plaintiff of convenience to be the nominal plaintiff, but as those of us who are lawyers know, usually the client goes to find the lawyer. When you've got cases in which the lawyer has gone to find a client in order to bring a case, that's a little bit of a red flag. So it comes throughout this whole scheme effort.
The ranking member for having this hearing, because the American people deserve answers and they deserve accountability. And not only are we seeing an ethical crisis in front of the Supreme Court, but it's really an institutional crisis, because it's about the separation of powers, it's about co-equal branches of government and their role in American democracy. So I want to be clear from the top that this is one of, if not the most blatantly political and activist courts we've ever seen in American history. As we've discussed here today, captured by special interests, dark money, and mega donors, and involved in transforming the very fabric of American rights and democracy with every decision. Abortion, the Clean Air Act, Clean Water Act, both tribal sovereignty, climate change, soon to be executive authority, and precedents that not only for decades but generations back into the 19th century. But it's not just the courts. We've also seen it here in Congress, because these same dark money interests and mega donors that we're talking about appear before us through their proxies every single day on the witness stand. In fact, we have had witnesses before this very committee that are funded by the very same donors that we're talking about here today, that are driving narratives that undermine from the legislative branch the very same institutional, democratic, and rights-based ideas that Americans have held dear for so long. And we've seen it time and time again. But I think it's important for folks to understand, as we've been discussing here, this is not a coincidence. This has been something that has been built over decades by these mega donors and the organizations that they fund. The Koch brothers, the DeVosses, the Harlan Crows, the Leonard Leos, and the candidates that they funded, like Donald Trump, and the Supreme Court justices that they hated to be appointed to and then funded the campaigns to make sure they got through the Senate confirmation process and also fund campaigns to ensure that they got there. While, meanwhile, these justices and their families have been going on multi-million-dollar vacations on yachts and private planes funded by the very same billionaires, while they have actual business in front of these courts through these dark money organizations. But I want to just say, you don't have to take our word for it, because a picture says 1,000 words. Or in this case, a $4 million dark money contribution to your Supreme Court justices. Here we have Justice Thomas with Harlan Crow. Their appointees. So I think it's fair to say that we not only have, as I said, a judicial crisis, but an actual crisis in the very institutions that underpin our democracy. I mean, that is really what we're talking about here. That is part of why I'm a co-sponsor of your bill, Senator, in which Mr. Johnson is leading on here in the House. It's why I also co-sponsored and introduced a bill with Representative to bring an Inspector General Supreme Court. But I think what the American people really want to know, and I get asked this every single day when I'm back home, is they want some real talk. How are we going to get this done? Given the reality of where we are right now, given where this body is at, given where the court is at, how are we going to get meaningful judicial reform?
The gentlelady's time has expired. Senator Whitehouse, please answer, and then we're going to go to Ms. Crockett.
In the dark days of the early World War II years, before America came in full force, Winston Churchill said to America, "Give us the tools and we will finish the job." I think that's what we need to tell the American voter. Give us your trust, the tools, and we will finish the job.
I couldn't have said it better. Thank you, Mr. Chairman.
Thank you very much, Ms. Stansbury. And now the distinguished gentlelady from Texas, Ms. Crockett, is recognized for 5 minutes.
And Senator, I am going to be cognizant of your time, because I am so thankful not only for your expertise, and I really want to tap into that for those that are watching. And don't realize the amazing attorney that you are, which allows you to be well informed as you are crafting legislation. But I want to make sure that we get you out of here somewhat on time. So I will not be reading from my prepared remarks. Instead, I just want to talk about a couple of things. One of the things that we have heard over and over and over, especially this term, is this idea of a two-tier justice system. We have heard that term used many times. So I just want to walk you through a couple of things and tell me if there really seems to be some differences to specific courts. So when we look at our lower federal courts, whether we're talking about the appellate level or we're talking about the trial level, would you agree with me that there is some form of ethics that is in place for our lower courts that somehow is absent from our high court?
That is correct.
When we look at things such as this idea of what or when a recusal should be in place, if I walk into a trial court right now and I feel as if a recusal should take place, in fact, we have a similar scenario taking place in Georgia State Court right now, where there are those that believe a recusal should take place. And while the trial court has ruled, they have the option of going to an appellate court. In the case of what has been laid out by so many of my colleagues as it relates to potential conflicts because your wife is potentially one of the perpetrators of January 6th or one of the planners of January 6th. And also, obviously, we've dealt with the upside down flags that are a sign of solidarity with those same January 6th defendants. What type of recourse do we have when there is a conflict that exists? And when I say conflict, I just want to be very real about this. There are people that have never been anywhere near a law school that are saying even a blind man can see there's an obvious conflict. But what is the recourse on the Supreme Court? Is there a recourse on the Supreme Court when a justice decides that they are not going to recuse themselves from what seems to be a very obvious conflict?
At the moment, there is not.
Okay. So I agree that there may be some sort of a two-tier justice system that is playing out in our country. But it seems like the two-tier justice system is inuring to the benefit of the highest court in the land, from what I can ascertain. And as my colleague has already laid out, Ms. Stansbury, the people want to know what we're going to do. And as one of the co-chairs for the Court Reform Task Force, there's 3 specific bills that we're pushing forward with that we really want to hopefully see brought to fruition. Obviously, we're not doing this in a full committee hearing because the people that are running the madhouse right now are not here for it. But we are, because we believe in law and order and overall rule of law. And so when we talk about things such as expanding the court, is there a history in this country of expanding the Supreme Court?
There is. It has been done by Congress.
It has been done by Congress at least 7 different times. And the last time was in 1869. Now, I know that this isn't necessarily your area of expertise, but would you agree with me that this country has grown just a little bit since 1869?
The population has considerably increased, yes.
Okay. So
we can agree on that.
It may make sense to do that. In addition to that, as someone who's practiced in state court and federal court, term limits exist in some form in a number of state court systems, but we don't have it on the federal level. Can you explain to us how potentially imposing term limits on the Supreme Court allow for hopefully some of the harm that we see coming through the court, some of the terrible influence to hopefully finally make its way out of the court?
Term limits for the court would, among other things, allow for a regular schedule of vacancies so that the court is not driven by the random fact of who the president is at a time when a vacancy emerges. And it would take away, or maybe not entirely take away, but make far less creditable the effort that was done to stop Merrick Garland and install Justice Gorsuch in his place. So it would make it far more regular and ordinary, and it would make it more difficult for partisan justices to time their departure from the court to make sure that their party gets to fill the vacancy. They claim to be completely apolitical, but they seem to try to clear out in the presidency of their own party. So,
Absolutely. Thank you so much.
And thank you, Ms. Crockett. I'm going to come now to our distinguished colleague from the Judiciary Committee, Mr. Johnson, for his 5 minutes.
The Oversight Committee for convening us today for this briefing. I want to thank our esteemed guest, the Honorable Senator Whitehouse, and the American people owe you a debt of gratitude. Before court reform became so popular, you were in the trenches doing the groundwork to bring it to this point where, you know, the data is there, the actions, the activities have been exposed, and the legislation to address those concerns is in the pipeline. And I just saw a notice from a news report that ethics legislation will be brought to the floor of the House of the Senate sometime this week. Will that be the CERT Act, or will it be some other ethics legislation?
we are having a series on the Senate floor this week, but I'm not aware that a vote has been scheduled.
Okay, well, maybe that report is...
I think the report was about our floor action.
Okay,
as
all right.
opposed to a floor vote.
Okay. All right. Well, nonetheless, I'm happy to be introduced House, the CERT Act, and of course the companion legislation in the Senate, which you are pushing, and also term limits legislation, which is very important, which would address the situation where the rot has taken hold. And rot tends to take hold in places where there's lifetime tenure with no accountability structures in place. Can you enlighten us, Senator, on the enforcement mechanism that is set in the CERT Act and how it could help when situations like
Commonwealth. The most important thing is that it directs the court to establish a process for its own ethics review. And if it refuses to, then we provide one. It remains, to be clear, an ethics enforcement program executed within the judicial branch. They don't have to come over to Congress. This is not that kind of an intrusion into the separation of powers. But at the moment, the situation is that if you have an ethics complaint about a member of the Supreme Court, there's not even an inbox to take your complaint. There's no clerk on the other side of the inbox to sort out the legitimate complaints from the nutty stuff. The legitimate complaints have no place to go within the court to be evaluated. There is no process for any justice to have to answer any question ever about what the actual facts are. There is no ultimate report that is ever provided about what the actual facts are, and there is no opportunity for any neutral body, say the Judicial Conference itself or a panel of the Judicial Conference, to take what the report declared and compare it to the rules as they enforce throughout the federal judiciary and say, this doesn't measure up. All of that can be built. All of that can be built within the judicial branch, and all of it would avoid the accountability chasm that is at the heart of the Supreme Court's ethics problems.
And without Congress taking action, is it your opinion that the Chief Justice, there's nothing that would prevent the Chief Justice from ordering an investigation of a complaint that may come to be filed against the justice, such as establishing a tribunal within the Judicial Conference to investigate and make recommendations? Is there anything that would stop the Chief Justice from doing that?
I would think that the Chief Justice would have pretty broad administrative authority to do that. He may choose to set up the process separately and then execute through the process. And he may wish to, doing so, there's a lot of there, and I don't want to comment in too much depth about that, but he is the administrative chief of the Supreme Court, and he is the chair of the Judicial Conference. And between those two offices, he holds broad judicial authority and the responsibility to see to it that the judicial branch of government operates and properly and with accountability and with transparency. He has those responsibilities, and he has the tools to achieve them, I believe.
Thank you. With that, I yield back.
Mr. Johnson, thank you so much for joining us. Senator Whitehouse, we want to thank you for working so hard to bring a little law to the Supreme Court and to their proceedings, and thank you for being an unflagging champion for the Constitution and the rule of law.
I'm grateful for the attention that you all have provided to this issue and look forward to working with you in the months ahead and perhaps even more happily in the Congress ahead to put this problem behind us. Thank you.
Very much so. All right, so here's what we're going to do. We're going to bring up now our second panel, and when we pick up with questions, we'll start with the people who were not given a chance yet, and that includes Mr. Khanna and Mr. Frost. I see Mr. Goldman has joined us. So please welcome to the dais there Alex Aronson, who's the Executive Director of Court Accountability. He previously was the Chief Counsel to Senator Whitehouse on the Senate Judiciary Committee. He's an expert on dark money in the court system and a policy expert on judicial ethics. Kate Shaw is a professor of law at the University of Pennsylvania. She focuses on the law of democracy, the Supreme Court, reproductive rights, and justice. She worked in the Obama White House counsel's office, and she currently co-hosts the Supreme Court-focused podcast called Strict Scrutiny. Kirti Datla is the Director of Strategic Legal Advocacy at Earth Justice. She focuses on anticipating and analyzing trends in judicial doctrine, including the scope of federal power and judicial review of agency actions. She worked at the U.S. Department of Justice's Office of Legal Counsel. Welcome to all of you. Each of you will be recognized for 5 minutes, and Mr. Aronson, we'll begin with you.
Ranking Member Raskin, Vice Ranking Member Ocasio-Cortez, and members of the committee, thank you for holding this important roundtable. The far right's capture of the Supreme Court poses an urgent threat to our democracy and shared prosperity, and I am heartened that you are giving it the attention it deserves. My name is Alex Aronson, and I am the co-founder and executive director of Court Accountability. We founded Court Accountability last year to sound the alarm about the right-wing court project. Our goal is to stop judicial power grabs by exposing and confronting corruption and anti-democratic abuses of power. This roundtable is an important step in that direction. The Supreme Court's right-wing supermajority did not come about organically. The justices who took away women's reproductive freedoms, made it harder for historically disenfranchised communities to vote, and overturned basic environmental protections came to power through a 50-year special interest campaign. Backed by self-interested billionaires and installed through unprecedented constitutional norm-breaking, this campaign was designed to undo the social and economic progress of the 20th century by turning fringe legal theories into constitutional law that binds us all. With roots in the massive resistance to racial integration after Brown v. Board of Education, the project gained steam with significant investments in the legal academy and other drivers of elite influence. The aim was to install anti-democratic modes of jurisprudence, most notably originalism, as the dominant forms of legal interpretation. These investments also built a pipeline of ideological movement lawyers loyal to their benefactors and eager to be installed as life-tenured federal judges. To shore up and reward that loyalty, providing $500,000 yacht voyages and free trips on private jets became a no-brainer for the justices. This roundtable comes at a critical moment. Justice Thomas's financial corruption, Justice Alito's ethical violations and brazen flag-waving displays of partisanship, and the complicity of Chief Justice Roberts in failing to rein in these MAGA justices have given the American people well-founded doubt about the court's impartiality and objectivity. Let me be very clear. It is heartbreaking that the American people are so quickly losing confidence in their Supreme Court. But they are right to be doing so. These far-right justices have delivered victory after victory to dark money interests at the expense of everyday people. Some of these conquests, like Dobbs, which overturned Roe and unleashed assaults on women's reproductive rights, or Bruin, which limited the ability of states and local governments to protect people from gun violence, are all too obvious. But Dobbs is just the beginning. We can expect further judicial attacks on reproductive freedoms based on radical, theocratic theories like fetal personhood to ban abortion nationwide by declaring it unconstitutional under the 14th Amendment. This would threaten not only abortion, but IVF, and would foreclose any legislative effort to protect reproductive freedoms. Some of the court's other rewards for its right-wing backers are more subtle, but no less harmful. The court's decision in West Virginia versus EPA, for example, deployed the novel major questions doctrine to severely curtail the government's ability to protect people from pollution and other harms. On issues of voting rights, dark money, and gerrymandering, the right-wing supermajority reliably uses its power to deliver victories to its allies. Although Bush v. Gore likely remains the high watermark for outcome rulings, the court's current treatment of the Trump insurrection case almost rises to that level. By agreeing so, these MAGA justices have arguably given Trump his biggest campaign contribution to date. If past is prologue, we should not hold our breaths for them to disclose the gift. One justice, Clarence Thomas, has refused to recuse himself from the Trump case, even though his wife, Ginny Thomas, was an active participant in Trump's scheme to steal the election. We learned recently that another justice, Samuel Alito, was flying not one but two MAGA flags associated with the deadly insurrection, and he too has refused to disqualify himself, defying the clear dictates of. In doing so, these made a mockery. At Whitehouse and members of this committee for advancing legislation restoring the courts. Congress should also use its clear constitutional power to strip or limit the federal courts of jurisdiction to overturn pro-democracy legislation like the Freedom to Vote Act and rights-affirming bills like the codification of Roe. As even a Trump judge recently affirmed, there is no real question that jurisdiction stripping is constitutional, and there's recent bipartisan precedent for it.
Mr. Aronson, can you just wrap up?
Yes, I'm about to
forgive
wrap
us,
up.
we're going to have to go vote soon.
Congress must use this simple, powerful tool, albeit sparingly, to preserve democracy, and it must exercise its inherent oversight authorities and disabuse the justices of their self-serving fabrication that Congress lacks power to oversee the court. Although I am clear-eyed about the difficult battle we face in reclaiming democracy from this authoritarian court, I am hopeful and inspired that you are taking the initial steps needed to start that process.
Thank you very much for your testimony. Professor Shaw, you're up for 5 minutes.
Ranking Member Raskin, Vice Ranking Member Ocasio-Cortez, and members of the committee, thank you for the opportunity to be here today. My name is Kate Shaw. I'm a professor of law at the University of Pennsylvania Carey Law School, and I want to focus in this opening on the relationship right now between the Supreme Court and democracy. When it comes to the court's recent substantive decisions, outside activities of some of its justices, and the court's responses to inquiries about those activities, the court is conducting itself in ways that are fundamentally inconsistent with basic separation of powers principles that are a core feature of our democracy. It is asserting enormous power, it is exercising that power in ways that are hostile to democracy, and it is refusing any and all accountability. This is crystal clear right now, as it is every June, as the country waits with bated breath to learn whether and how the court will upend huge swaths of American law. This year, questions include whether and how the court will further erode the capacity of agencies to regulate in ways that protect our health and safety and well-being, whether the court will permit government to limit the possession of the most lethal forms of firearms or the ability of dangerous people, including abusers, to possess them, whether the court will allow the laws passed by Congress and signed by the president to be used to hold accountable the individuals charged with the attack on the Capitol, including the former president. And the court is asserting that it, and essentially it alone, will decide all of this for all of us. And although we don't yet know how it will rule, in recent terms, the court has proceeded without a shred of humility vis-a-vis the democratically elected actors in government who... So the separation of powers, it is dynamic, it's not static, and to a degree that is healthy. But allowing one set of institutional actors to dramatically expand their authority and resist accountability without meaningful challenge or pushback risks permanent damage to our constitutional structure. So let me say a few words about the court's recent cases. In many ways, the court has not only acted in ways that are inconsistent with the role of a court in a democracy, it has undermined or threatened basic precepts of democracy. The first panel really covered, and Ranking Member Raskin, you talked about Citizens United, you talked about Shelby County, Bush versus Gore, so I won't rehearse all of that. But I think that we're maybe to sum all of that up, where the court was once understood as largely or primarily functioning to facilitate democracy, it's clear that this is a court that no longer views that as its primary or indeed a role that the court serves at all. Maybe less obvious, but equally important, is the anti-democratic character of the court's decision in Dobbs. In overruling Roe versus Wade, Dobbs perversely claimed to rest upon or vindicate principles of democracy. But it returned the question of abortion to the democratic process at precisely the moment when the court itself has ensured the system is unlikely to yield widely desired outcomes. In addition, the history and tradition method the court used in Dobbs is a wildly undemocratic one, binding the recognition of constitutional rights today to a past in which very few Americans were meaningful participants in the production of law and legal meaning. This deeply anti-democratic strain is also on display in the court's administrative law cases. In those cases, the court has weaponized a highly skewed vision of both the separation of powers and democracy to fundamentally undermine those values. This has been particularly stark in the court's major questions cases, in which the court has deployed this newly articulated doctrine to disable agencies from acting under broad grants of authority from Congress. This term, the court is considering, among other things, whether to overrule the 40-year-old Chevron doctrine and whether to declare unconstitutional much of agency adjudication. Again, we don't know exactly what the court is going to do in those cases, but if it continues on its current trajectory, I am fairly confident that it's going to curtail agency power, and it's going to be, when it does that, it will be profoundly undemocratic in at least two ways. First, each of the agency power cases I just mentioned involve challenges to agency actions that are the result of democratic choices made by Congress and administrations of both parties. But second, and in some ways more fundamentally, these challenges are direct attacks on the democratic values of equality and pluralism. The cases that in recent terms have sought to reduce state capacity have been most focused on agency agencies at the center of the project of inclusive and multiracial democracy, financial regulation, labor protection, consumer protection, reproductive rights, environmental protection. Okay, so that's the court's cases. Let me just briefly say a couple words about accountability. A core feature of the separation of powers is that no single individual or institution possesses unchecked power. That is elemental. But there are lots of examples from this court that it no longer believes in that principle. It believes it enforces the separation of powers, but is not subject to it. Last July, Justice Alito essentially told the Wall Street Journal Congress did not have the power to regulate the court. That is inconsistent with the text of the Constitution. It is not just Justice Alito, but the Chief Justice, who has used, less confrontational tone, but similar substance in his unwillingness to even meet with Senators Durbin and Whitehouse in their efforts to simply address questions of ethics and the court. It is imperative, to my mind, I'll make this my last point, that Congress communicate to the court that it is serious about questions of oversight, and I think it cannot let the Chief Justice have the last word, even in that small exchange, because allowing it to stand for the Chief Justice to have the last word, to my mind, is ratifying the notion that Congress, the court is not obligated to participate in the project of congressional oversight. There are lots of ways the committee can follow up, ask for a meeting with a member of the Chief Justice's staff, submit questions in writing, but I think it's critical that the Chief Justice not be allowed to simply have that refusal stand. In the interest of time, I'll wrap here, but I very much look forward to your questions. Thank you.
Professor Shaw, thank you very much for your excellent remarks. And I'd like to now recognize Ms. Dotloff for your 5 minutes.
Thank you, Ranking Member Raskin, Vice Ranking Member Ocasio-Cortez, and members of the committee for the opportunity to speak today about some of the doctrinal changes that the Supreme Court is making. I want to spend my time discussing how the efforts to reshape the federal courts during the Trump administration are bearing fruit in judicial decisions right now, and what this means for the real people who depend on the kinds of protections that the laws that I work on, the Clean Air Act, the Safe Drinking Water Act, and statutes like that, provide to all of us every day. So to start, to their credit, I guess, the conservative political actors who had the power to reshape the federal judiciary and who used that power to do so were quite honest about what they were trying to do. So in 2018, Don McGahn, who was then the White House counsel, spoke at the Conservative Political Action Conference and explained that the Trump administration's approach to judicial nominations was part of a coherent plan in which judicial selection and the deregulatory efforts of the administration were really the flip sides of the same coin. And in 2022, Senator McConnell explained that the Trump administration viewed the Federalist Society as a farm team of potential judges who were of a like mind. And now, the people who are in a position to take advantage of the reshaped courts have also been quite clear about how emboldened they are now to use the courts to advance their agenda. As an example, last November, a senior attorney at the Pacific Legal Foundation, which is a group that describes one of its core areas of work as restricting the authority of federal administrative agencies, said that for them, money is never going to be a problem. And so for them, it's more efficient to achieve their goals by litigating, including all the way up to the Supreme Court. That's more efficient than lobbying with administrative agencies or winning political campaigns. So given this setup of well-funded, highly motivated litigation groups and a primed judiciary, it's no surprise that the federal courts, including the U.S. Supreme Court, are now issuing decisions that advance multiple lines of attack on the way our government is structured now and how it operates. This setup is what produced decisions like West Virginia versus EPA, where the court changed the rules of the game when it comes to interpreting statutes like the Clean Air Act, because it was in pursuit of what Justice Kagan described as a broader goal of preventing agencies from doing important work, even though that's what Congress directed. And this setup is how we got decisions like Sackett versus EPA, where again, the court provided evidence that the Supreme Court has, and again, using Justice Kagan's description, appointed itself as the national decision maker on environmental policy, in that case on the Clean Water Act. So what does this all mean for us? The kinds of environmental laws that I work with are bedrock important statutes that were designed to allow us to solve pressing problems. Can we trust that our drinking water won't cause cancer? Can we send our kids to walk to school and know that the air they breathe is not going to give them asthma? And on and on. And Congress knew what it was doing when it wrote these important laws. Congress recognized that these are serious problems. It set clear goals for our country to meet, and then it entrusted federal agencies to carry out those commands. It did so because it understood that those agencies have the necessary scientific, economic, and technological resources to make sure that Congress's commands in these laws are carried out. And Congress also gave us, the public, who has a vested interest in making sure that our water is drinkable and our air is clean, the ability to influence that process before a federal agency. And though things aren't perfect, this system has led to progress that we can and should be proud of. But in a world where the federal judiciary makes these decisions without giving respect to federal agencies and the statutes that Congress wrote, and perhaps even looking at them with a skeptical eye going into these cases, the world will look very different. This world is a threat to all of the progress that we have made and to our ability to do the work that still needs to be done to meet the goals and the agenda that these laws have set, and that so many fought so hard for, and that protect us from the kinds of unchecked pollution that puts us at risk. Thank you.
Thank you very much for your excellent testimony. We're now going to resume with the questioning, and I'm going to start off with Mr. Khanna. You will be recognized for 5 minutes, and we'll go through with the members who haven't questioned yet, and then we'll see if we have a few minutes left for a second round.
Well, thank you, Chair Raskin and Vice Chair Ocasio-Cortez, for convening us. Mr. Aronson, as you and many have testified, Justice Thomas accepted numerous gifts from Harlan Crow, including free trips, yachts, private jets, private school. Now, I know sometimes we think this is very complex, but it's actually pretty simple. Harlan Crow then has a real estate firm which has a case in front of Justice Thomas while he's giving them these gifts. Now, I don't think you have to go to law school to know that this is of interest. Am I?
Disqualify himself in any proceeding in which his impartiality might reasonably be questioned. Of course, this is a statute that is implicated by his flag waving situation, and it's certainly implicated by reasonably by this decades-long relationship and by the happy acceptance of all of this free luxury travel.
And then Justice Alito, to your point, he has a stop the steal flag flying in front of his house. Now, his First Amendment rights, he says he can't tell his spouse what to do. I can't tell my spouse what to do, but that's not the issue, right? I mean, the issue is, should he have a stop the steal flag in front of his house and then be presiding over a January 6th case? Again, doesn't seem like you have to be in law school to know you can have a stop the steal flag, but you can't then adjudicate a case that's about whether the election was stolen. Am I missing something there about the conflict of interest?
Congressman, I don't think you're missing something. I think Justice Alito has been assigned to deflect blame to his wife, Martha Ann Alito, just as Justice Thomas has tried to deflect blame and association insurrection to his wife. Justice Alito does not contest that the flag was flying outside his home. He does not contest the political significance of the flag. He says it was his wife's to fly the flag. She's fond of flying flags. I'm not. But that's not the question presented by the recusal statute. And his conclusion that no reasonable observer would be able to question his impartiality is just, flatly false.
I just want to say, and then I want to turn to Professor Shaw, that the Supreme Court justices have taken 344 gifts valued over $3 million. I mean, Congress, but we're limited to a gift of $250 to put it in context. Total unaccountability for the Supreme Court. Professor Shaw, you may not know this, but do you know the average age that a Supreme Court justice typically leaves the Supreme Court?
I don't.
It's 78 years of age. A number of years.
that we are currently experiencing. So I think that that is one aspect of what is so broken about the Supreme Court right now.
And are there any requirements in the Constitution that someone be appointed to the Supreme Court for life? I know you have to be a judge for life, but is there any requirement that you have to be on the Supreme Court for life?
Well, hold office during good behavior has been understood to apply to all federal judges, and life tenure is how we've translated that. The phrase is not in the Constitution, but that's how we've always understood the Constitution.
But it could be that someone is on the Supreme Court, has term limits for 18 years, and then goes to a circuit court or some other judge, right? They can be a judge for life as long as they're not on the Supreme Court.
I think there's a very strong argument that our ordinary understanding of a requirement of life tenure could be, implemented in a different way than life tenure on the Supreme Court. Could be implemented in a way by statute without constitutional amendment, whereby a justice would serve for a term on the Supreme Court and remain a judge on a lower court without requiring an amendment to the Constitution. I think that's an argument that has a lot of merit.
And my last question, do you think it's reasonable then to have term limits for Supreme Court justices given their penchant for fancy gifts, more years they stay, and given how out of touch they are with basic norms of modern America?
Well, I also think that in a comparative context, almost every state has term limits or age limits for their Supreme Court justices, and there are good pragmatic reasons for doing that. So I think the pragmatic reasons are strong, and there are arguments that one could do it without requiring a constitutional amendment, which under Article 5 is virtually impossible today.
Great. Thank you, Professor Shaw. And thank you, Congressman Gunn, for your excellent questions. One quick correction. We are limited to $50 gifts, not $250. It's 50. Yeah.
I haven't taken it. He just.
Well, in fact, it's a good opportunity.
Maybe in Silicon Valley it's different.
No, we know that the distinguished gentleman from California takes no gifts at all, which is why he didn't know that. But Congresswoman Ocasio-Cortez and I are actually introducing legislation to just deal with a piece of the problem we're discussing today, which is to apply the $50 gift ban, which works fine in Congress, to the Supreme Court itself. And we're going to be unveiling that this week. I'm going to now recognize from Florida, Maxwell Frost, for his 5 minutes of questioning.
Thank you so much to Ranking Member Raskin and Vice Ranking Member Ocasio-Cortez for bringing this together. The integrity of our judicial system is something that I've had to focus on pretty intently in the state of Florida, especially of recently. We had a state attorney who was plucked out of office, Monique Worrell. Just recently, the stacked state Supreme Court, which is completely compromised, full of DeSantis lapdogs, just completely throughout the case. And so we'll see what happens in November with reinstating her in the will of the voters. The Supreme Court issued a landmark ruling in the Bruin decision, which raises major concerns about the influence of dark money from wealthy right-wing donors. The Bruin decision, which struck down New York's century-old law requiring individuals to demonstrate a special need to carry a concealed weapon, represents a major shift in the Second Amendment and the way we interpret it. This decision is championed by the gun lobby and big gun lobby players like the NRA, and some of the biggest contributors to the NRA are billionaires like Charles Koch and Leonard Leo. Leonard Leo spent at least $950,000 to overturn affirmative action by paying the plaintiffs and outside groups who wrote supporting briefs. And dark money groups backed by Leonard Leo also poured tens of millions of dollars into funds dedicated to dismantling voting rights and promoting gerrymandering in the wake of Shelby County versus Holder, which gutted the Voting Rights Act. The recent adoption of a formal ethics code by the Supreme Court lacks the robust enforcement mechanisms that we need, and the revelations surrounding Justice Thomas and his undisclosed fund billionaire Harlan Crow highlight the urgent need for more transparency and accountability. So, Professor Shaw, there's been a lot of reporting on the influence of dark money as a court, and specifically Justices Thomas and Alito. But for those who aren't familiar, can you discuss a little bit on the influence that the NRA and dark money networks have had on Justice Gorsuch and Justice Kavanaugh's confirmations?
I'm not going to be able to cite chapter and verse, but there have been in recent confirmations there has been a significant increase in money spent by outside groups, the NRA and many others. I mean, I think that in some ways the story of the transformation of the Second Amendment goes back much, much further, right, than the recent confirmations of President Trump's appointees to the Supreme Court, and really begins with the 2008 case of District of Columbia versus Heller, and then the 2022 Bruin decision that you mentioned. And in both of those instances, a very broad-based multi-platform effort that involved a lot of expenditures of funds, but also the development of scholarship and sort of a gets to the part of keeping and bearing arms. And for all of our history until 2008, that was understood as securing a right consistent with or exercised in conjunction with militia service until the court fundamentally in the 5-4 Heller decision changed that. So the NRA, I think, across a lot of different platforms involving, both money, but also suasion of various sorts, fundamentally changed the meaning of this key provision of the Constitution. And the court in 2022 supercharged that interpretation of the Second Amendment. So to my mind, money is some, but not the entirety of the story of the transformation of the Second Amendment and of the meaning of many provisions of the Constitution in the last couple of decades.
And on Second Amendment interpretation, the court's decision in Bruin to impact state and local gun regulations like those in Florida?
It ties the hands of government, whether we're talking about the federal government, the states, or local government. It makes it very, very difficult to successfully defend a firearms law against a challenge under the Constitution unless you can point to a specific historical regulation that looks like the regulation under review. And in the case of interventions that are only needed today because firearms and firearm violence looks different today than it has looked historically, it's going to be virtually impossible to find a historical antecedent that's going to satisfy this Bruin test. And so it's a test that seems kind of devised to lead to the invalidation of most firearms laws. We will see what the court does in the Rahimi case. There's also the Cargill case, two important gun cases pending right now. So Rahimi could involve some rolling back of some of the kind of maximalist logic of Bruin. But right now, I think it makes it extraordinarily difficult to enforce meaningful gun laws.
And if we institute the kind of reforms that Senator Whitehouse spoke about in the first plan and a lot of folks are advocating for, will this pull the Supreme Court back from the opinions that donors are championing?
Thank you, Ranking Member Raskin and Vice Ranking Member Ocasio-Cortez for convening this important roundtable. St. Louis and I are here today to tell some hard truths about the myth of impartiality of Supreme Court justices. Many of my colleagues have lamented the clear and egregious violations of the measly, newly implemented ethics standards that exist for the court. Is it appalling that Justice Alito and his wife showed public support for the Stop the Steal movement in the days after January 6th, after the insurrection, while the court was ruling on the 2020 election case? Absolutely. And yes, the recordings of them that were released just yesterday provide a revealing glimpse at their extremism. But this scandal, we know, is just the latest example of the longstanding corruption and the extremism of the right-wing injustices. The truth is, the Supreme Court has never been completely impartial. They weren't impartial in 1857 in the Dred Scott v. Sanford case, a case arising out of my district in Missouri, where the Supreme Court decided black people could not be considered American citizens. No surprise, because the Dred Scott court had 4 people who enslaved black people on it. Justices, I'm calling their names, James Moore Wayne, Peter Daniel, John Campbell, and John Catrone. The U.S. Supreme Court wasn't impartial in 1927 when avowed eugenicist Justice Oliver Wendell Holmes wrote the opinion in Buck v. Bell, upholding the forced sterilization of people with disabilities, or in 1986 when the majority of Supreme Court justices in Bowers v. Hardrick displayed, quote, an almost obsessive focus on homosexual activity, unquote, according to their own peer justice, I keep saying Justice Harry Blackmun in his dissent. This obsession led them to green light the criminalization of gay and lesbian relationships in that decision. I could go on and on, but in the interest of time, The sooner that we accept this, the emperor has no clothes, obvious truth, the better equipped we will be to put in meaningful safeguards to prevent people with clear bias and vested monetary interest in the outcome of the U.S. Supreme Court cases from deciding those same cases. At minimum, Justice Alito should recuse himself from all cases related to the 2020 election. The Senate Judiciary can investigate, and depending on the facts, there should be an impeachment inquiry, as is true for Justice Thomas and his many, many outrageous scandals. But both Justice Alito and Thomas can spare themselves. They can spare the federal judiciary and our country from further humiliation by resigning right now. But we can't count on these men to do the right thing. This is why I, along with my colleagues, have reintroduced the Judiciary Act this Congress, a bill that would add 4 seats to the U.S. Supreme Court, bringing the bench from 9 to 13 justices. This is just one of the many crucial reforms needed to dilute and control the almost limitless power these corrupt justices yield. We know that the corruption of the Supreme Court, it affects us all in the next month, including its blatantly pro-insurrection wing, will rule on access to medication abortion, the rights of unhoused people, and Trump's claim of immunity against prosecution in connection with January 6th. Their lack of neutrality has been so irrefutably documented that if Congress genuinely wants to restore the public confidence in the judiciary, it must remove the lawless justices, enact ethics reform, expand the court, and institute term limits. So, Professor Shaw, I'd like to ask you about the decisions that these far-right corrupt justices are handing down. What does this mean for real people like in St. Louis? So can you talk about the real harms that are caused on our communities by these SCOTUS decisions?
Sure. I mentioned in my opening some of the impact, some of the regulations that have been targeted in some of the recent administrative law cases. Maybe I'll just say a couple of words about the abortion cases on the court's docket right now. So the court is considering an outlandish challenge brought in Texas to mifepristone, one of the 2 drugs used in the medication abortion protocol, brought by a group of anti-abortion doctors with the most tenuous of claims to a legal right to be in court, challenging the FDA's approval and regulatory decisions. And yet, a district judge in Texas sided with them on both their ability to be in court and their substantive claims of invalidity of the FDA's approval. The Fifth Circuit rolled that back to a degree, but did agree that some of what the FDA had done, loosening restrictions on access to mifepristone, was unlawful. They've been allowed to be heard in the first place. So the Supreme Court is currently deciding what it's going to do with that case. I think most likely the standing analysis below is too much even for the Supreme Court to accept, and so that case will be thrown out on standing grounds, and so mifepristone will remain available on the terms it is currently available on. But there's another case waiting in the wings brought by a group of states instead of doctors, and that case, I think, could well be before the Supreme Court in a year or 2. So we're talking about access to, often needed, widely used medication that is the most common method of ending a pregnancy across the country, and the court has the ability to render that essentially unavailable to all Americans, potentially in this decision, but certainly in a decision within the next year or 2. So I think that's one example of the kind of cases and the kind of stakes that we're talking about.
Yes. Thank you so much, Professor Shaw. I yield back.
Thank you very much, Ms. Bush. I recognize the distinguished gentleman from New York, Mr. Goldman, for his 5 minutes.
Thank you very much, Ranking Member Raskin and Vice Ranking Member Ocasio-Cortez. Thanks to our panelists for being here. Too much to discuss in a few minutes, but I want to touch upon this most recent issue related to Justice Alito. As you probably know, Congressman Johnson, who was here earlier, and I led a letter of 45 of our colleagues to Justice Alito laying out the obvious and clear conflict of interest he had under any code of ethics and as well as the Constitution and federal law. At the same time, wrote to meet with Chief Justice Roberts. In response, Justice Alito sent a letter back to all of us. And it's quite a remarkable letter, and I'm sure you will agree. Mr. Aronson, you discussed it a little bit, and the first thing I would point out is there is no mention of any of the court's precedent on this issue.
there is no mention of the fundamental notion that no one can be the judge and jury in his or her own case, which has been applied to judges' decisions on recusal, right? There's nothing in his explanation that addressed those, correct?
There's not.
Okay. Then you were talking about 28 U.S.C. 455, which is the federal recusal statute, which applies to any justice, judge, or magistrate judge. Is there any way to interpret that as to exclude Supreme Court justices?
No, Congressman, it very explicitly applies to Supreme Court justices.
In his letter justifying why he is not recusing, Justice Alito cites to the Supreme Court's new, and I intentionally use air quotes, ethical code of conduct, which is non-binding and non-enforceable, and uses the standard in the Supreme Court's code of conduct, which says that a justice should disqualify himself or herself in a proceeding in which the justice's impartiality might reasonably be questioned. And then in the code of conduct, there's an example of that. That is this identical language, is it not, to subsection A of section 455, right?
Correct.
Okay. He does, now, I agree with you wholeheartedly. It is a bastardization of an analysis of whether or not anyone could reasonably question his impartiality. But I want to go to subsection B of the federal statute, which he does not address. And in this subsection B, it states that he shall also disqualify himself in the following circumstances. Subsection 1, where he has a personal bias or prejudice concerning a party. Now, let's give him the benefit of the doubt and blame everything on his wife, because that's very convenient. I suppose you could make an argument that he has not exhibited a personal bias by his wife hanging a clearly political flag on his house. But there are also recent revelations where they're not in a recording that he views his role and the political landscape right now as whether one side or the other will win, and he pretty clearly puts himself on one side. Is that what your understanding of that recording and reporting in the Rolling Stone is?
I think that's a fair interpretation of that recording. I think, given the kind of the vague, context of that recording, I wouldn't hang my hat necessarily on recusal on B1 as strongly as the first provision you mentioned. But I think there's certainly an argument that he should recuse based on personal bias, particularly given what we know of Samuel Alito's long-standing partisan affiliations and to the outcomes and goals of the party's agenda.
Right, and to be clear, we are an effort to if he had some bias. In my last couple seconds, I will do another section here, which he does not.
a witness in the January 6th committee and who was directly involved in Trump's Stop the Steal movement. It very clearly requires Justice Thomas's disqualification, even more so than it might require Justice Alito's.
Great, thank you. And I think as I
your leadership and your passion on this, and I'm going to turn to distinguished, beloved colleague from Massachusetts, Ms. Presley, for 5 minutes.
Infected, and we need transparency. And while Republicans have ignored the crisis at the court, today's hearing is critical for letting the American public know how extremists on the right are coordinating across branches of government to enact wholesale, widespread policy violence. Mr. Aronson, have you heard of Project 2025?
Congresswoman, yes, I have.
My colleagues and I, we've been raising the alarm on Project 2025, a far-right manifesto that has hundreds of pages of extremist policies to destroy the federal government as we know it. Everything from a national abortion ban to eliminating the Department of Education, to mass firings of civil servants to be replaced by partisan sycophants. Now, much of this focus has been on agencies in the executive branch, but it also implicates the judiciary. The only way right-wing extremists will be able to ensure their policies are carried out is if the Supreme Court will back them. And that's where people like dark money racketeer Leonard Leo step in. The Senate Judiciary Committee recently subpoenaed Leonard Leo as part of the Supreme Court ethics investigation. Mr. Aronson, can you explain briefly why Leonard Leo is under investigation?
I believe Mr. Leo is under investigation by the Senate Judiciary Committee for his central role, not only in, the selection of decades worth of right-wing judicial nominees, which is not the direct target of the inquiry, but for his involvement in the scheme to reward the
and the discrediting and the smearing of Anita Hill. Let the record reflect, I still believe you, Professor Hill. Leo's work to undermine democracy goes beyond the Supreme Court. He has used his dark money network to fund Project 2025 to the tune of more than $50 million. The only way the Heritage Foundation is able to promote their anti-democratic agenda is through funders like him. Now, Leonard Leo is reported to be behind lawsuits for the Supreme Court to end Chevron deference. Mr. Aronson, can you explain why that matters when it comes to harmful policies from a conservative administration?
Yes, Congresswoman. I'm so glad you brought up Project 2025 and its intersection with the court. It is no coincidence that the very same collection of dark money entities, over 100 groups that have sponsored Project 2025 and its sweeping plans to repeal the 20th century through installation of personnel and reorientation of our policies, are the same ones that have been behind the decades-long court capture scheme. And, the agendas are connected in very direct ways that my co-panelists have sort of touched on in terms of the attacks on the administrative state and in terms of plans to install a almost monarchical vision of the executive branch, drawing from decades of investment in something called the unitary executive theory that members may recall from the Bush era when it was advanced to support President Bush's despicable torture program.
Well, again, Project 25 is only able to be successful if the Supreme Court allows it. So Congress must act. We have to expand the court to create balance and fairness. We need a binding, enforceable code of ethics to ensure accountability. We need investigations into Justices Samuel Alito, Clarence Thomas, Brett Kavanaugh, and any others with a record of impropriety on the highest court in our nation. And we desperately need court reform to defend our democracy and save lives. And a point of personal privilege, I would just love for people to make it make sense for me that Justice Alito can't tell his wife what to do, but he can tell me what to do with my body. Make it make sense. Thank you.
Thank you for your powerful questioning and testimony, Ms. Presley. Appreciate it. Coming to the distinguished gentlelady from Michigan, Ms. Tlaib, for her 5 minutes.
Thank you so much. Thank you so much to Ranking Member Raskin and our amazing Vice Chair Ocasio-Cortez. This is so incredibly important because I get asked about this all the time in my district. I really do. I know they call it the ethics crisis here in Washington, D.C., but do you know what they call it in Detroit? Do any of you can guess? I don't know. Ranking Member Raskin or Vice Chair Ocasio-Cortez, what do you think Detroit calls this? Do you think they call it an ethics crisis?
No, they probably call it a corruption crisis.
That's right. It's exactly what they call it. They don't even call
we don't talk to people.
Oh, yeah. They don't even call Justice Clarence Thomas Justice Clarence. They call him Corruption Clarence. That's what they call him because they're fed up. They're incredibly angry and frustrated that, when you look at the definition of corruption, I don't know if y'all looked it up. I was like, let me look at the difference between the definitions. You got corruption, dishonest or fraudulent conduct by those in power, typically involving bribery. So I would love for you guys all to, so we already know some of these, right? So by the 20 years, no reporting at all by corruption. I'm going to call it what my residents call them, corruption clearance, 20 years. And then all of a sudden we find out 38 destination vacations, 26 private jet flights, 6 helicopter flights, and multiple yacht trips from Republican billionaires, billionaire mega donors like Crow and others. And it is amazing to me that, and then you get to Justice Alito, it was some Alaskan fishing trip? How is that not corruption? This is not an ethics crisis. The American people know what it is. It's corruption. It's bribery. That's why they're yelling, impeach them, remove them. Any other person on any other job, when it comes to any of my residents, would be gone in an instant. And so, for me, I think we should begin to call it what it is, out of respect to the many of the people that are impacted directly by this. And that's where it gets to you, Director Delta. Delta. I got you, girl. So, Director, I have to tell you, I come from a community where we had to start We Have a Right to Breathe campaign, where I thought, smelling like sulfur dioxide and hydrogen sulfide, all that smell was normal. So when I think of all the work we have to do to address the climate crisis, but really to address the fact that right now, even under current processes, my residents call it permission to pollute, right? We have oversight, but is it really stopping them from getting sick? Where we have residents that are putting white crosses in front of their homes because it was a white cross campaign. If you have cancer or survived cancer or died of cancer, you were told, put the white cross so people can visualize that our whole neighborhood has been literally paying the toll of investing so much in fossil fuels. And again, this is a predominantly black and brown community. So I want to, hear from you. And I think it's important because I know my residents feel the corruption, know what does this mean, right? All the actions that we do in Congress, I always tell them, if you look at the Civil Rights Act, it got watered down by the courts. It got weaker because of the courts. We can't even have disparate impact as a threshold to show that your civil rights have been violated. So, Director, why is the Chevron deference important to the average American?
I think at the most basic level, this doctrine, so just to lay it out very quickly, it's the idea that Congress writes statutes and it tells agencies to carry them out. And implicit in that is the idea that the agencies are supposed to take a first crack at addressing any questions that come up. And so just to give you an example of the types of questions that come up in the statutes that I work on and that you're referencing in the Clean Water Act and the Safe Drinking Water Standards Act, these statutes refer to things like what's the best practicable technology available to control pollution. It's a complicated term that doesn't necessarily have an answer you can find from looking from a dictionary. And so Congress told agencies to figure it out, to apply their expertise, to apply their technical knowledge, and to listen to input from the public. And all the Chevron deference framework says is that when an agency does that right, when it follows the process, when it applies its best judgment, and it reaches a reasonable conclusion, courts, which aren't in a position to do any of those things, should defer to the agency's interpretation. And that means that when groups like your constituents go to an agency, win some progress before the agency that has a direct impact on their health, it's stickier with the doctrine of Chevron deference. It means it's more likely to be a real victory that lasts than if it's subject to the veto by some judge somewhere in the country. And so it might sound technical, but it really does make a difference for all of us.
And so we have a corruption crisis on literally an entity that could really impact our residents. Do you know, I go into some of my schools and there's literally garbage bags over their drinking fountains. Garbage bags over their drinking fountains. You know, Shirley Chisholm, the first African woman serving in Congress, used to say, children can't learn if they're hungry. I really believe children can't learn if we're poisoning them. It's not just the aerosol, it's the water and so much more. And it's not just lead. I keep reminding people, it's 11 or more toxins now that are in our water. And now we're going to go ahead and allow this unchecked, unfeathered, group of folks that, again, have been, I think, in many ways corrupted for quite a while, making these decisions that impact our residents. Thank you again for this hearing. I think it's so important. Thank you.
Of course. Thank you, Congresswoman. And the chair now recognizes the gentlelady from Pennsylvania, Congressman Lee.
Thank you, Vice Ranking Member, and of course, gratitude to you and our Ranking Member for holding this really important discussion that is increasingly clear we will not get from our Republican colleagues. As someone who spent a little bit of time in law school and since then, and getting a little bit of flashbacks from how particular and specific our conversations will be, I'm going to try to have a layman's conversation here, because demystifying the court is actually one of the most important things that we need to do right now. And as we're looking towards Project 2025 or all of these other issues, the capture of the court, we need folks to really understand that this is not as complicated as they might think it is. So in September of 2022, Chief Justice Roberts said that he doesn't understand the question about the Supreme Court's legitimacy. Since then, we've seen documented cases of justices being wined and dined by billionaires. They're failing to recuse themselves in cases where their wives are embroiled. They're displaying insurrectionist flags, as we've heard, outside their houses, all with zero consequences. So whether we like it or not, the Supreme Court, as Rep. Tlaib just said, is absolutely in a legitimacy crisis. We can call it a corruption crisis, an ethical crisis, or a legitimacy crisis. They all fit. Over half the country doesn't approve the actions of our Supreme Court. And that doesn't just mean approval of their rulings. That's the approval of the job itself that they're doing. In November, the Supreme Court tried to placate us by adopting a code of ethics. But it's clear that we have to go farther. Mr. Aronson, if a justice violates one of their adopted ethics rules, who investigates that violation?
There is no provision in the ethics code that provides for any investigation of the justices. They leave it up to themselves to self-police.
So what are the consequences then of a violation, and who would enforce those consequences?
Congresswoman, the Supreme Court has made clear that they don't think that they can be held accountable either by Congress or by the Judicial Conference, which does regulate and discipline the conduct of lower court judges. So there's nobody to hold them accountable at all.
Sticking there. So we essentially have a code with no teeth or function. It just serves as a way to get people to stop complaining and to keep the status quo. So as a lawyer, right, we have to take the MPRE, we have to take continuing legal education classes in ethics, and we can be disbarred, we can be suspended. There are many mechanisms to hold us accountable. Professor Shaw, when a lawyer violates an ethics rule, who investigates that and sanctions that lawyer?
Every state has its own bar disciplinary authorities, so there's a formal process in every state, and that's the process that gets invoked if there has been an ethical violation.
So what about when a state court judge violates their ethics code?
Again, the mechanisms vary state to state, but there are state disciplinary bodies that do have significantly more investigative and enforcement authority. There have been a couple of episodes actually recently involving arguably abuses of those disciplinary proceedings, targeting justices for unpopular statements or rulings. So that can be abused. But the point to your question is that it exists, and it's a meaningful mechanism of enforcement of ethical guidelines.
Question, how about when a member of Congress is accused of an ethics violation? Who investigates and enforces that?
I think the
Chair, Vice Ranking Member Raskin might know the answer to that one.
I think the ethics committee would do that, right?
We do have an ethics committee. So the rest of the legal community and members of Congress are subject to actual ethics standards and enforcements. No matter how effective they are, they do exist. And yet our Supreme Court, the Supreme Court of the land with lifetime tenure, has decided that they don't need that level of review or scrutiny. And we don't need to go into how hypothetical bad actors would exploit this system. We're seeing it right now. Ms. Statla, could you tell us how billionaire Charles Koch and billion-dollar trust fund manager Leonard Leo have helped to fuel litigation and court rulings that limit our ability to mitigate the devastating impacts of climate change that are underway?
Yeah, so I'm unfortunately not an expert on the direct connections on the financing side of things, but what I can say is that in many of our cases, we see multiple groups raising the same kinds of legal arguments, and it's just impossible to look at the briefing objectively and to say that there's not a significant degree of coordination and a significant amount of resources going into coming up with the arguments like the major questions doctrine, like setting the stage for overruling Chevron deference, that are detrimental to efforts to address climate change and other pressing environmental impacts.
Thank you. We've seen reports noting that, for example, Koch has featured Clarence Thomas in at least one exclusive meeting, as we've talked about, with his closest donor allies, along with Leo. And Leo has arranged luxury travel for Clarence Thomas and Alito to meet with billionaires. With time in mind, because we are about to go and vote. Just really quickly, Mr. Aronson, what is the recourse if a justice doesn't recuse themselves from a case?
Well, a party to the proceeding could bring a motion, as Congressman Raskin has proposed that the Justice Department do in the Trump insurrection cases, to disqualify them. Ultimately, it would still be up to the justice themselves whether to recuse themselves from that case. And if I could amend my last answer just a bit, there is a process by which the Judicial Conference can review willful failures to disclose, financial disclosures, and refer those questions to the Attorney General. The Attorney General does have a role to play in enforcement.
Thank you. And obviously, we can go much further, as we've seen our colleagues propose today. I just want to conclude by saying we shouldn't be living in this alternate reality that believes our Supreme Court is free of corrupting influences. At this moment, where our climate, reproductive justice, voting rights, protections for our trans and our queer siblings, and our fundamental guardrails against racial discrimination are all under threat, this court is being wined and dined by the very people that profit from this pain. So we must call it out for what it is and seriously address this corruption that exists in our legal system. Thank you again for being with us today, and thank you for convening us.
Thank you, Ms. Lee, for such an excellent set of observations and questions. Panelists, you guys have done a fantastic job, and you can see why I'm so proud of the Democrats on the House Oversight Committee. They're called the Truth Squad ever since they debunked and demolished the ridiculous impeachment drive against President Biden. But today, we are the Truth and Justice Squad. Let me just follow up one question, and I'll see if Ms. Ocasio-Cortez has any final thoughts. But I want to follow up on something that was prompted by Ms. Lee's questioning, which is we've had a lot of judges in American history at every level, the state level, the federal level, the trial level, the appellate level, who've done things wrong, right? We've had judges who have taken bribes and been impeached for it. We've had judges who have sexually harassed clerks. We've had judges who have engaged in party activity. We've had judges who've owned human beings as enslaved people. So there's nothing magic about being a judge or a justice. I mean, do any of you believe that there's some reason that we shouldn't have an ethics code that binds judicial officers the way we have binding ethics codes on legislative officers or executive officers? Is there any reason? Yeah.
Mr. Aronson?
More than that, Ranking Member Raskin, I think there's reason to have higher standards for justices who are supposed to be impartial and to hold themselves above reproach. And as we've learned from this past year's devastating scandals, are very clearly not living up to that higher standard that they should be held to.
Yes. And how about you, Professor Shaw? Do you have any final thoughts for us on that?
I mean, I think that the rules of the road have basically been trust us. That's essentially been the representation that the justices have made. And I think the public has maybe been willing to make that bargain when they believe the justices comported themselves in a noble and honorable fashion consistent with the rule of law. I think there's every reason to believe that maybe that was never the case. It's certainly not the case now. And it seems there's a pressing need for some more formal mechanism than trust us to ensure the highest levels of ethics and our highest court.
And it's certainly not the right time when we have such unequal justice coming out of the court and such sharp wealth inequality in society where people lead different kinds of lives. We made one poster, if somebody would put it up, I asked my staff to try to find out what's the average amount of money spent on a family vacation in the United States. I think we've got that someplace if somebody would get it, and I think it was around $3,000 if you go to Disney World for a long weekend with your family. Is that right? $2,840 is how much is spent on an average American family's vacation. One of Justice Thomas's 38 sugar daddy-sponsored vacations was more than $500,000. And I'm sorry, but if you're making $300,000 a year from the taxpayers, pay for your own damn vacation, right? Ms. Dalla, what about you? Any final thoughts?
Oh, I don't think I could put it any better than Professor Shaw did.
All right, Ms. Ocasio-Cortez, did you have any concluding thoughts for us?
Of course, I think one of the major takeaways and what is important about so much of what we've discussed today is that the Supreme Court is a stone's throw away from this building. They are 9 justices that wear robes, but they are not gods, nor are they priests. And this idea that their authority is self-generated and that they are accountable to no one or nothing is not just wrong. It is one of the most direct and dire threats to American democracy today. Because any degree of authority without accountability is a seed of tyranny, and it is a seed of authoritarianism. And we are seeing that play out today in the stripping of rights and bodily autonomy of women and people across the country, in the stripping of labor rights and labor movements of people across the country, in people's right to drink clean water and breathe clean air. The constitutional and democratic crisis and threat that this current corruption crisis on the court presents is a threat not just to American way of life and American democracy, but it is a threat to our lives. People have died and are dying after the Dobbs decision. People have died and can die with the rollbacks of environmental provisions. We've seen this in the dumping of PFAS and toxic waste throughout the United States. These are our lives on the line. And the corruption crisis presented by the court is not just an offense to our democracy. It is not just an offense to our morals. This is about people's lives on the line and who are being sacrificed for greed. And for what? And so I think the takeaway for us today is that the responsibility of this harm is not just solely on the court. It relies in Congress. It lies in Congress. Because it is not just when an individual seeks to abuse their power where our democracy fails. It is when there is a lack of accountability and standing up and response to an attempt at tyranny that our democracy fails. That is why it is important that we have accountability after January 6th in an attempted insurrection and involvement to overturn the United States, the results of the United States presidential election. And it's why we need to have truly important, sweeping, and strong response to the crisis of corruption on the highest court of this land. And with that, I yield back to the ranking.
Well, thank you, Ms. Ocasio-Cortez. The Senate, of course, gets to render advice and consent on Supreme Court nominations and judicial nominations generally. We don't have that constitutional power. We've got some other powers they don't have, like we have the power to impeach
for example. But we nonetheless have a very powerful institutional interest in integrity on the Supreme Court, and we're going to exercise our power, and we're going to exercise our responsibility to help oversee integrity in the judiciary. And I want to thank my colleagues for doing such an outstanding job today on this. All of us who aspire and attain to public office, whether it's the legislative branch, the executive branch, or the judicial branch, are nothing but the servants of the people, whether your title is president or justice or congresswoman or senator. We are all servants of the people, and we have a particular function that's constitutionally defined to play. And none of us is above the law, and none of us is above the Constitution, and all of us must remember that we are ultimately serving the people of the United States. So I want to thank our distinguished panel, Ms. Dadla, Professor Shaw, Mr. Aronson, for your terrific presentation. We want to thank our colleague, Senator Whitehouse, for coming over and talking about the work that has been such a labor of love for him for many years now. And I'm glad that so many people have been tuning in from around the country to this very important dialogue. And we are picking up some traction, and we're going to be able to make a lot of changes in the weeks and months and years ahead. So thank you all for participating. And with that, this session is adjourned.